everybody. My name is Aaron DeVore. I'm the chair in Transgender Studies, and welcome to our first webinar. Quite excited that you could all join us. Here at the University of Victoria, we always start with a territorial acknowledgement. And so we acknowledge with respect the Lekwungen-speaking people on whose traditional territory the University of Victoria stands, and the Songhees, Esquimalt, and Masonish people whose historical relationships with the land continue to this day. A little bit of housekeeping information before we launch in. So this event will be recorded, is being recorded, and will be posted online, so everyone who couldn't make it today at this time will be able to see it later. Just be aware there is a Q&A at the end that will not be recorded, so just the lecture will be recorded. So because this is a webinar, that means that your mic and your video is automatically turned off, and it will be off for the entire presentation. But the chat function is not active. If you want to ask questions, there is a Q&A box, and I encourage you at any point in the webinar to type in your questions in that box. I will ask questions of our speaker after the presentation. No one who is attending will see your name or your question. That's just for us who are running the webinar. If you do not want us to see your name either, there is an option to ask the question anonymously. You'll see that when you go into the Q&A box and start your question. So a little bit about Chair in Transgender Studies for those of you who are new to us. We were the first chair in transgender studies in the world. There's now another one, I'm very pleased to say, at the University of Buenos Aires in Argentina. Our goal is to provide reliable, solid information about the real world to drive social change, to make the world a better place for trans, non-binary, two-spirit, and other gender diverse people. And we try to help build healthy communities by facilitating activities that are of interest to the trans, non-binary, two-spirit, gender-diverse people and allies. So a couple of the things that we do that are quite significant. One is that I founded the Transgender Archives, and along with the University of Victoria Libraries, we run the Transgender Archives, which are the largest collection anywhere in the world of original historical materials about transgender activism and research and transgender life in general. There are other collections around the world that are LGBTQ, but this one is trans. And our collections are these original documents, which is what historians use to write the history of trans people from, because very little of that history has actually been written so far. So our records, when you try and say how big is an archives, you say how long would the shelf be if we put everything on one shelf? And our shelf would be a football field and a half long. That's 160 meters if you think in meters. They go back over 120 years. They're in 15 languages from 23 countries on every continent except Antarctica. Right now, you can't visit us in person because of COVID, but a lot of our material is available online. There'll be links at the end of this broadcast, and I encourage you to go to our webpage. There's a wonderful discovery tool that you can get to from there that will show you some of what we have and some of our content, and we're putting more up online all the time. Please feel free to email us if you have specific requests or about our collections. Another major activity that we, the Chair in Transgender Studies, sponsors is the Moving Trans History Forward conferences. We did have one scheduled for 2020 that was going to be live. Again, COVID got in the way. We are going online. And so our online conference will be March 11th to 14th in 2021, this coming spring. Please, if you're not on our mailing list already, join our mailing list, and we will get information out to you. Watch our social media. Again, all that information will be available to you at the end if you're not already connected to us. So we're going to put out a call for proposals on that soon. We have a scholarships and fellowships program. We've just recently announced this year's winner, so it's not open for applications at this point, but please check out our website to see who the winners are, and stay tuned because many of them will be doing webinars with us throughout the year. We also do a whole series of arts and cultural events. We are engaged in gallery exhibitions. We have had performing artists in film screenings, some stuff coming up in the new year, and social gatherings such as our ever popular Nachos Night, which we're trying to figure out how to do that under COVID restrictions as well. So that's just a brief overview. There's lots more I could go into, but I'm not going to delay any further, but I would like you to take a few minutes to watch a short video about the chair in transgender studies.
The Trans Archive has been very much an eye-opener. The Trans Archive is very diverse, and it is such a rich body of work that is available.
Transgender Archive and training in transgender studies are a very special place for me. I hope every researcher about transgender have opportunity to come here. I don't have the same opportunity in Japan.
Yeah, the experience has been great. Everyone was really friendly when I was corresponding to get stuff set up for my visit. I'm gonna miss it. I don't want to leave.
We have nothing but curiosity to lead us forward. So first of all, just breathe curiosity.
Thank you for your attention to the video. Now, to move into the main event of the day. Adrienne Smith is our speaker, is a transgender human rights activist and social justice lawyer. They hold a double honors BA in English literature and geography, a master's in human geography, and a JD, Juris Doctor, all from the University of British Columbia. Adrienne is the recipient of the Canadian Bar Association BC Diversity Award, the Canadian Mental Health Association, BC Branch Nancy Hill Public Policy Leadership Award, the Allard Law Alumni Achievement Award, and the Vancouver and District Labour Council Sid Thompson Award for community service.
Thank you, everybody, for joining us from home. I'm trying something new. So if I'm a little bit slow advancing my slides, it's because I'm practicing with a remote mic. So thank you for being guinea pigs in this project. Let me begin by also acknowledging the territory that we are on. I am coming to you live from Musqueam territory, which is shared with the Tsleil-Waututh and the Squamish people. This is unceded stolen land. It is occupied by force. And every day that I wake up as an uninvited settler and decide to stay here, I'm contributing to a colonial project. And as Uncle Ben said to Spider-Man, with great power comes great responsibility. And because I benefit from a fundamentally unjust system, it's my job to help to dismantle that system, because Indigenous folks on their own, working from the margins of a system that is meant to exclude them, will not be able to dismantle colonialism. And I'll say also that I'm profoundly committed to a decolonization and the payment of reparations, which must happen before reconciliation. And I would very happily pay my rent to Musqueam rather than the place I'm paying it now. Awesome. Apparently my video has been spotlighted for everyone. I'm gonna move us back to the slides that I'm showing. This is a picture of me reminding myself to make credentials for election day, but it has a dual purpose here of reminding me why you should listen to me. I am a human rights lawyer working almost exclusively for transgender people, a social justice activist in my community, where I'm openly non-binary in all the places, even when it's not safe, and I'm a lifetime labor activist. So pick the one of those that gives me credibility for you, ignore the others. Here are some of the places that I've worked alongside other trans folks. If a dump truck full of money should appear at your front door, please give it to the Catherine White Holman Center and to Pace Society, who are doing some very heavy lifting at the moment in this apocalypse to keep trans folks housed and alive and fed. I think I was afraid you would not take me seriously, so here's a photograph of me inside the Supreme Court of Canada. Sometimes this is a role that I play. This is me outside the Supreme Court of Canada, and I think this is a more accurate picture of who I am. Here's what we're going to talk about today. I've been asked to speak on advances in transgender law. The punchline of this talk is that legal change and legal battles, though important, are not the total solution to the world that we find ourselves in. And I hope that that's not a contentious view, particularly as I'm delivering it to a group of predominantly non-lawyers. We're going to talk today about existing legal protections. I'll do that part quickly. I would like to express my profound gratitude about giving a public talk without having to go through a trans 101. It really warms my heart that we're in a Zoom together in everybody's independent living room with the same language. It makes me feel like I'm home. So thank you for that. We'll skip the 101. We'll talk about existing legal protections. I'll do this quickly. I'll make this PowerPoint available for you later, and also the video will be archived if you'd like to look at some of these slides more closely. Law students get very excited and want to write everything down, but you will have this. We'll talk about some of the foundational cases that reinforced what our current legal protections are. And then we'll talk about what's new and what to expect in the future. Is that acceptable? There's a question in the chat about whether these laws pertain to the United States. I'm called to the bar in British Columbia only. Some of what I'm going to say has persuasive legal power in other jurisdictions. Some of the things I talk about will have to do with the federal Canadian state. American law is not something I'm qualified to practice, and it varies significantly by state because of differences between the ways that our countries are structured. So let's put a bright box around BC and Canada, and I would refer you to the ACLU branch in your state for more specific directions, and also to trans people working in your communities who are the frontline experts in their own experience. Okay, let's go. I don't mind if you intervene in the way that that person just did. I find this professor thing kind of awkward, and I really would prefer that we were all together in the same space and you could just wave a hand at me. So do make use of the Q&A if there's something that you really like to jump in about as we go through. Let's talk about current legal protections. The Canadian trans people are protected theoretically by all the laws that protect all Canadians. Our foundational constitutional document is the Canadian Charter of Rights and Freedoms. Trans people are protected under the equality provision, which is section 15, and the section 7 protections, which is life, liberty, and security of the person. And this particular provision, section 7, is the most lively and vibrant of charter provisions at the moment. This is where the Insight case happened. This is where the Bedford case around the right to sex work safely occurred. And this is also where right to assisted suicide. Most of these groundbreaking social justice cases are argued as Section 7 cases. Section 15 is a somewhat atrophied section of the Charter, the equality provision, but there's a whole graduate seminar we could do about why that is. Of course, the criminal code also protects trans people from all of the other issues. I'm just going to reach for my criminal code right now because I want to make a point with it. Here it is. It's a nice big one. This is the list of all the crimes that are prohibited in Canada. But of course, all these things still happen all the time to all kinds of people, which is largely why there are criminal lawyers, which helps to underline my punchline that law is not enough. There's a question about whether the Charter is like the Bill of Rights in the US. In the US, you also have the Declaration of Independence and a number of constitutional amendments that make up your collection of constitutional documents. You also have state constitutions and state regulations. Canada has this very British history that the United States departed from. And as a result, that means that the ways that our approach to human rights are different in predictable ways. But some of what I'm saying is useful, but yes, it's vaguely a parallel document. So we're protected under the criminal code for things like criminal harassment, hate speech, assault, sex assault. We know these things all happen all the time anyway, and trans people have particular barriers accessing protection in the criminal justice system because of the way the law discriminates against us from the beginning. In Canada also, there are federal and provincial human rights legislation. People ask me why there are two, and it's because some enterprises are regulated federally, like ports and the post office. Some things are regulated provincially, and you pick the human rights legislation that applies to your thing. So if we're talking about education, because here we are at UVic, that's a provincial issue. So we would pick the BC Human Rights Code if we experience an issue with the university. They don't stack. So often people ask me federal questions when they mean provincial, but that's your practical tip for the day, I think. It doesn't matter for us because the wording is almost identical in the provisions. We're protected on the basis of sex, of gender identity and expression, and also of disability, but I would be very reluctant to file a human rights complaint on the basis of disability alone for a trans person, unless they also had a disability, because I don't feel like there's anything wrong with us. My gender is not a diagnosis. But we find ourselves in this place where the duty to accommodate principles, which are limited by the limit of undue hardship, apply to trans people. We are also protected by a variety of provincial legislation and policies. So workers' compensation, you can make a claim if you're psychologically injured. They also have some bullying and harassment regulations, which are not as strong as they should be. And patient rights, the freedom of information and protection of privacy legislation that's quite important for trans people in a way that it's not for others. There's also a suite of really underdeveloped civil protections. Tort law is how people sue each other. This is a set of civil wrongs, which are different than legislated wrongs. And the tort of intrusion into seclusion has been successfully argued in Ontario for trans people. The remedy and what you get as a result of going to court for this kind of thing is an area of law that needs to develop more. But this would cover things like stalking and outing and some of the doxing, many of the harassment issues that we see coming up constantly, or would be covered as torts when people would need to sue one another, which of course leads to the question, how do trans people possibly afford this? Many of our collective agreements also protect us, usually in a blanket clause that gives us a right to a harassment-free workplace. There may also be trans inclusion policies. I'm going to pause there because I see a question. Hello, friend, who's asking this question. There's a question about how using the criminal code to enforce equity rights, particularly in the context of the code's role in criminalizing us. Yes, I will talk about that. I'm glad that you are anticipating this, because using the state's law to persuade the state to protect us from itself is a paradox that we can't really get past. Those blanket protections that I've just finished telling you about all have an exception or an exemption. So the Charter's equality provision allows for ameliorative processes or affirmative action. So you can design a women's employment program, and that is not in itself discriminatory because it's meant to address a problem with women's participation. Here's the federal human rights exemption. There's another one about the universality of service for soldiers, which I sometimes talk about. It's the rule that says soldiers need to be able to be deployed anywhere, and this is how we keep insulin-dependent diabetics out of frontline service, for example. And this could prohibit trans people, provided they needed some additional medical care, which is not always true. Parallel provision is what Trump is using to keep trans people out of the military in the United States, with the falsehood that trans people require extra health care. And when actually we are getting the access to healthcare like everyone else, we have no more onerous healthcare needs than other people. Mostly I just need asthma medicine. These federal and provincial exemptions exist for the purpose of making people who start in a subordinate position on a binary be able to be raised up. So we can do targeted equality programming, which is not in itself discriminatory. These exist in order to head off like men's rights applications for protection under these human rights codes. Sorry, I'm going the wrong way. This is the special program that allowed Vancouver Rape Relief to discriminate against Kimberly Nixon. I think that case was wrongly decided. We'll talk about that in a minute, and I think it would be decided differently today. I think also it was an overt abuse of what is meant to be an ameliorative section of human rights legislation. So here is the exemption. We'll get to it later, but I wanted to tell you what it was so we could talk about it later. What are not exemptions? There's a question, can people get my slide deck? Yes, absolutely. And this video will be available for rebroadcast later, so you can put your pens and pencils down if you're struggling to keep up. I'm just doing the law part quick. We'll talk about real people in a little bit more depth. What are not exemptions or exceptions to human rights protection are other people's discomfort. Other employees' discomfort, customers' discomfort. You can't say you're not allowed to wear a skirt in the workplace because our customers would think that it was weird. That's not a thing that you're allowed to say. Similarly, good intentions aren't an exception, neither is ignorance of the law or religious belief. And similarly, free speech and academic freedom claims do not automatically moot human rights protection. And I've got a whole other talk that I will tell everyone about once I finally write it, about the limits of free speech freedom of expression and academic freedom, because it's a really complicated area of law. It's too big to cover right now. But what I'd like you to take away is that arguing that it is free speech or academic freedom or a religious belief doesn't mean that you're allowed to treat trans people badly automatically. That's not, it's a falsehood. What is interesting is that there's been a huge push for explicit protection and recognizing trans people in clear legislation. Here's a photograph of me in my lawyer pajamas with a bunch of liberals that we met that day, and some really courageous trans people who've been fighting for the preceding 2 decades in order to get this put in the legislation. I think many folks thought that this fixed the problem and then it was done. We're far from there, but it was a moment to celebrate, and I'm glad that we did. I could give you a long citing about the difference between formal and substantive equality in Canadian law. In American jurisprudence, the differences between equality and equity. Formal equality means, like, here's this typical picture of these 3 kids in front of a fence watching a baseball game. The problem is they need to pay to get into the baseball game and they can't. And so there's a tall kid standing on one box. The middle kid is standing on a box. The little kid can't see. The previous image, of course, would be these kids standing on the ground when only the tallest kid could see. And treating everybody the same gives everybody a box. Everybody gets the same box. This is a visual demonstration of formal equality. Substantive equality, which is the leading school of thought in Canadian constitutional and equality jurisprudence, is that we treat people according to what they need. So in this second image that I'm showing, the little kid has 2 boxes so that they can see over the fence. The middle kid has 1 box so they can see. The tall kid doesn't have a box because they don't need a box. I think this is a problem if we think of formal recognition as the end point of where we're going, because it doesn't address, I think, with an exception that I'm about to show you whenever you Google pictures of this equality, equity demonstration, the kids are always white. Here's the exception. And I would like to draw, for folks who do not see this image, there's the substantive equality, or formal equality listed as equality here, substantive equality listed as equity here, and then real radical liberation, which is when we knock down the fence. And the problem is not that people need handrails or affirmative action hiring programs, it's that we need to remake the world to create the justice of the existence that we want, rather than acknowledging that things are bad and dangerous and then seeking to reform them in small ways. And this is why I'm arguably too radical to be a lawyer. But to my friend's point, where's the reasonableness, knowing that the state and police and the military and the administrative state itself, knowing that they are sources of harm and violence to trans people, how appropriate is it for me to be standing here in my lawyer pajamas in front of these decision-making spaces, asking the state to protect me from itself? And how do trans people do that at the same time that we're being disproportionately murdered with impunity? And there's no legal aid for us particularly. I think it's a very serious problem, and it makes all of these rights that I've just told you about really contingent, and for many people illusory. These are paper rights that can't be enforced because getting in to see a lawyer and accessing the programs that would be able to make them real is out of reach for us. I think that means there's nails on the top of the boxes in front of this fence in front of the baseball game. Let's talk about some foundational cases. The first is Sheridan and sanctuary investment. This is the least creepy picture I could find of the bar in Victoria that had been operating as BJ's. It was the one gay bar in Victoria operating under sanctuary investment. Sheridan was a woman who came to the one gay bar and got a hard time because she didn't look like her ID, and they didn't let her use the bathroom. They were going to make her use the men's room. So she complained to the Human Rights Tribunal. This is 1999, and since then, there's been a rule in BC that trans people can pick the facilities that correspond to their gender identity. We're still fighting about this every single place, but Sheridan establishes this rule. I think Ferris is also a very interesting case, and it establishes unions' liability for including trans people. For folks interested in employment law, imagine there's a taxi company. All the men use the men's room. All the drivers are men. 2 women work in the office. One's a cis woman, one's a trans woman. The union rep got a call from the employer saying, we've had a complaint about your trans member using the women's room, the women's bathroom. And the rep said, oh, okay, I'll deal with that. If that happened today, I would tell that employer to go away because she has every right to use the bathroom. It's 1999, of course. But the rep didn't do that. And he also felt like it was really a private women's issue, and maybe that this woman would want a woman steward, and the steward is the union rep assigned to help her. Didn't ask her. In some places, the choice of a steward is so sacrosanct in labor law that any decisions that are made by a replacement steward you didn't choose are moot. But the rep made a choice for the member. He was also weirded out by her and didn't call her. So the replacement steward, who turned out to be the woman who complained about our member using the toilet, the rep and the employer sat down for an investigation meeting. The member didn't come because nobody told her it was happening, and she was subsequently disciplined for not coming to an investigation meeting. For those of you who practice labor relations, this is horrifying. Her collective agreement obligations, entitlements were solved in arbitration, but she brought a freestanding complaint against the union and was successful. And the rep's name and the company and the name of the union are all published in this extremely humiliating case. Unfortunately, the member's name also had to be there. And the cost for being public in this circumstance is so much greater for trans people than it is for other litigants who are not trans or non-binary. But when I meet employers who are hesitant about whether or not they are interested in identity politics, I tell them about this and how embarrassing it was and how expensive it was. This is Nixon and rape relief, which is the next significant case. Rape relief argued. I'm going to say some things that may be upsetting for trans and non-binary folks about this case. So if you want to just mute me for 30 seconds. What rape relief argued was that Kimberly was a man in a dress, and they said that their sex assault survivors would be essentially triggered by having to deal with her on the telephone, which is horrifically untrue and part of a anti-trans hate campaign that has been going since before this date, really. I think it's bad law. I think it would be settled differently today, but it does say that nonprofit organizations can come up with employment programs that privilege certain groups which are not discriminatory. And a reasonable and appropriate application of that exception is to say, we're only hiring cutie BIPOC folks for this role, not to say we're going to exclude trans people in favor of cis women. I have so much to say about this case, but we're going to move on. This is Boyd Kodak. He was arrested by the Toronto police because of a dispute he was having with a former business partner. He's a trans man who wears a packer. They took this from him in cells, passed it around the police precinct, made fun of him, and he settled in mediation with Toronto police. But the details of that settlement, these are usually secret, but we know what it was. And now the rule is that you're not allowed to take people's prosthetics away and make them wear clothes that don't conform with their gender. They made him wear women's clothes in cells. They released him to the public in women's clothes, particularly underwear, which is devastating. And he got to have his packer back. And that was 2012, which is not that long ago. There's a question here about Nixon. They say that they The person says, in Nixon, I believe they relied on an exemption that was in the BC Code. It is still in the code. I showed it to you earlier. That exemption in the code that rape relief relied on still exists. I think it was wrongly used because it's meant to support ameliorative programs that support folks farthest from justice, not to reinforce glass floors against folks who are also struggling. So it's still in the code. I think it's badly used. I think some of the cases we're about to talk about really dismantle it as a source of good law that people can use to exclude trans people from services. It still exists and they rely on it very much on the other side of this argument, which is that trans people are people. But back to Boyd, he really changed the way that the Toronto police were policing. This is Avery Edison. She's a trans woman who overstayed her student visa. And because at that time we sent minor immigration infractors to prison, and because Avery had not had bottom surgery, she was sent to Maplehurst Prison for Men. And they didn't take her phone away from her until she got to prison. So she live tweeted the whole thing, which is still available on Twitter if you'd like to occupy yourself for an afternoon reading those horrific tweets. In the bottom corner is my picture of my fantastic Toronto doppelganger, whose name is also Adrienne Smith, who got Avery out of jail and then forced Ontario Corrections to change their policy for how they're housing people. And now people get sent to jail according to their gender identity. This caused federal BC Corrections for provincial jail also changed their policy to conform. So did federal prison rules, which means, and then Vancouver following the Dawson case that we'll talk about next. So the only place that trans people are likely to be held according to their anatomy and not their identity is RCMP cells or other municipal police force custody locations, and for the 48 hours until they come before a judge. And then they go to provincial housing, which should take them according to their identity. This is not happening, and I do represent folks who are incarcerated in holding populations that are wrong for them, but the rule is clear that it shouldn't be happening like that. This is Angela Dawson. She goes by Roller Girl. Some of you may know her. She likes to direct traffic. And as a result, she's frequently arrested. In a couple of occasions, the police booked her under her dead name and used the wrong pronouns for her, even though they know that her name is Angela and she uses she, her. She says they did it to give her a hard time, and I believe her. They also denied her medically necessary health care when she was in cells. And she got a tremendous settlement and forced the Vancouver Police Board to change their policies on first contact with trans people, on transportation of trans people, and on housing of trans people in at least Vancouver City cells, and working with the VPD to make sure that the way that they're caging members of my community is some of the weirdest lawyering I've ever done. Yeah. But there's Angela. Her case was incredibly, it's noteworthy because the damages were so large. She got $12,000 or $15,000, which is order of magnitude greater than what the tribunal had been issuing until that point. This case also established that dead naming and misgendering are freestanding human rights violations, which is very useful for trans people trying to access services. Here's Bray, who lives in Victoria. When the Senate was debating whether trans people should get explicit protection, Senator Plett said that trans people should use the toilets that conform with their bodies. Here she is with her viral Twitter campaign, showing her in the wrong bathroom. This is Harriet Cunningham, who caused the BC government to change the Vital Statistics Act to remove the surgical requirement before people could change the sex or gender marker on their ID. And I think it's so important that Harriet's case didn't go to a hearing. And many of the advances that we've had in the last little while, I'm going to tell you about a few of them, are uncelebrated and not supported by a decision. It's just something the government was persuaded to do, which is, I think, a great benefit of having not conservative governments provincially and federally for us, because you can call them and say, can we fix this? And they say yes. This is True Wilson, who I went to celebrate because she made the Catholic School Board change their dress code, which really set a promise for other trans kids who are going to schools that have uniforms to be able to dress according to their gender identity. So what's new? One of the spontaneous things this government did was step away from binary gender markers for BCID. Here's the X that is suddenly available. We used to be restricted to binary M's and F's. I have concerns with the X because nobody's gender is X. They also rolled it out in a terrible way. We still require a doctor to say your X is appropriate. Here's a waiver that people who want an X have to sign, which seems to require people to contract out of protection from the human rights regime. And I told the Attorney General that that was a problem and should change. They copied it almost entirely from the federal waiver, which is similar for federal documents. And in addition, unlike Ontario and some other Canadian provinces, the display of the marker is compulsory here. So this puts people in a position of finally being able to choose a marker that isn't binary if they're non-binary people like I am, but having to decide whether it's going to be safe for them to exist in the world with an X, because it makes every traffic stop, every liquor store trip, every border crossing more dangerous than it would have been otherwise. And the person from MSP who was in the meeting that I had with the Attorney General about the problems of this X marker said, well, we wanted people who were applying for an X to know that they might encounter problems. And those of you who don't identify in the binary, you know what the problems are already. You don't need the government to tell you that. But that's a as yet unsolved problem, that this X still exists. We've had another secret advance about employment insurance. I had a client who came to me because they wanted to go on medical EI, which is what many people do when they're recovering from gender-affirming surgical care. But in order to apply, you had to pick a sex, and there were two choices. So my client picked a letter. I don't know what letter they picked because they needed these benefits. They're misgendered by the online form, and then came to see me and said, can we fix this? And I said, yes. So I called the lawyer that we would have served the federal human rights complaint on and said, can we fix this? And 36 months later, they added an other. It's like a T or a question mark or some other option now. And then the government issued a self-congratulatory media release saying that they had done this fantastic thing. But it was just in time for 10 million people to apply for EI in the midst of this global pandemic without having to be further misgendered, which I think is a good thing. And I'm really grateful to my courageous client for having fought that through with me for 36 months pro bono. Here's the choice now. You can be male, female, or X. This is a screenshot of the current EI application. Again, nobody's gender is X. I'm going to talk about the Morgane Auger case, and there's going to be a bad image of the flyer that the opponent in her case posted. It's an image that shows her picture, dead names her, and misgenders her. I've blocked out those pieces, but I want people to be able to brace or turn their video off for about 30 seconds. Here's the flyer. Morgane, of course, ran, she's a trans woman, and she ran to be a member of Parliament, or a member of the Legislative Assembly in Vancouver Falls Creek. And William Whatcott, who law folks will know as a famous hate speaker, who once distributed letters to mailboxes in Saskatchewan talking about the homosexual agenda in schools. William Whatcott made this poster and posted them all around the constituency. There was also a leaders' debate happening in the corner. I couldn't find a clearer image. This case is significant because it sets out the criteria for what contemporary transphobia looks like. And it includes misgendering and dead naming. It points out that there's these binary divisions in the legal system, in administrative law, in all the places that, you know, non-binary and trans people are finding them. Here's the tribunal saying that they are true and they exist. But they also point to this significant denial of validity of trans people's identities and an appeal to biology. So calling people real women or saying that a trans person is really their assigned sex. Mental health slurs saying that trans people are somehow mentally ill, and requirements for validators from lawyers and doctors, and increasing what Cott wanted Auger to submit to an independent medical exam that would prove who she really was. But also, contemporary transphobia is characterized by a denial of service, by threats and harassment, by over-policing, and by conflating trans people with sex offenders. There's a question, someone wants to know what dead naming is. This is when we refer to somebody not by the name that they have chosen, but by the name that they were assigned. So the name your mom picked for you. If we call Caitlyn Jenner anything other than Caitlyn, then we're dead naming her. Because we know her name is Caitlyn, she's told us that's what she wants to be called. We have a human rights obligation to call her that. So some celebrated Ontario professors who are refusing to do this, or who are refusing to refer to their students by appropriate pronouns, are going to face discipline by their employers. Here's a caption from Auger and Whatcott. I'm not able to see what the time is from where I am. Aaron or Ian or Michael, would you let me know how much more I've got?
Hi Adrienne, this is Aaron speaking. You have about 25 to 30 minutes because you've been taking questions as you go along. So we're going to give you a little bit longer to speak.
Okay.
Get out of the Q&A period that was going to come at the end.
I will panic less, and you can give me the imagine you're sitting in the front row and you can hold up a 5 more minutes sign for me. I would love
I'll
that.
do that. Okay.
Thank you. And also thank you all for having me into your house or office. It's such a weird time I cannot acknowledge. So here's a quote from paragraph 62 at Auger and Whatcott, which talks about this particular denial of validity and worthiness and dignity and respect, and the allegation that trans people aren't who they say they are may not look like discrimination to people who aren't experiencing it. So the panel at the Human Rights Tribunal really set out what that looks like. This is a long decision, and it also pulls all of the previous human rights litigation about trans rights into one clear decision. So if you're litigating in this area, of course you're going to cite Auger and Whatcott. If you're writing a paper in this area, this is a good case also to cite because it contains everything nicely. And the citation for this is 2019 BCHRT 5861. Again, it's Auger and Whatcott. There is another aspect of this case, which is that this stereotyping of trans people as diseased, confused monsters and freaks, and our conflation, the conflation of transness with sex offenses. Is the unspoken part of how trans people are demonized by folks who oppose rights, with this sort of unspoken or often spoken assumption that if trans people are given access to spaces, they will necessarily behave badly in those spaces, which is mean and wrong and transphobic. And here the tribunal says just that, which I think is very helpful. I'll also talk about this most recent case with a very courageous 14-year-old boy. He asked to be anonymized by the court. I think most of the lawyers working on trans rights in BC were in on this case or the following case at the BC Court of Appeal. AB is a 14-year-old boy. CD is his father. EF is his mother. This case arose out of a family law dispute between CD and EF, who are parents, who are also separating and had a very uncomfortable relationship. CD had some concerns about how EF was parenting AB because AB is trans. And what he wanted was what is pictured here on the right. This blue container and this syringe contain Lupron. And Lupron is a drug that we use for a couple of purposes. One is to delay precocious puberty in cisgender kids. So if your 6-year-old girl starts getting periods, if your 6-year-old, anything. If your 6-year-old starts getting periods, we would give them Lupron to delay things. AB wanted this in order to prevent the estrogen-driven puberty they may otherwise have had. And eventually they wanted to start testosterone. His mother was very supportive and did all the things, referred him to Children's Hospital, had him assessed. They were very careful and assessed him many, many times. The hospital tried, the pediatric program at Women's and Children's tried to involve the father, called him in for many appointments to talk about what he could expect and what was going on to try and get him on board, because that's their ordinary practice, but also because Lupron can be prohibitively expensive and somebody needs to pay for it. CD disagreed that this should happen and sued everyone involved in AB's life. The teacher, the school counselor, all the doctors at the clinic, lawyers for the mom personally, and sought an order prohibiting this boy from directing his own healthcare. And what the court found at the Supreme Court of BC was that AB is old enough and young people can consent to their own healthcare if the doctor does a best interest of the child test and it's in the best interest to do this treatment, and if the young person understands the benefits and risks of the treatment. So the informed consent that all of us do when we get healthcare. If those two things answer yes, neither of the parents' opinion matters. And healthcare providers are very comfortable about this when they're providing, say, birth control to young people. I never needed a letter from a parent in order to get hormonal birth control. But we seem to have this barrier for gender-affirming, life-saving gender-affirming care for young people. I think the court was persuaded that this was life-threatening because AB had made some attempts on his life several times. And the court found not only was he old enough to decide his own health care and his father couldn't stop him, but that his father should not talk about the case and threaten the anonymizing. The father did just this and gave interviews to, they describe themselves as family first organizations, who published the boy's dead name and identified him, making the fact that he was anonymized problematic. It also found that the father trying to speak to this boy to talk him out of being trans was a form of family violence, which in British Columbia has implications for parenting time, for what we used to call custody and access. That particular part, the family violence aspect, was overturned on appeal. But the other things, that this young person can consent to his own health care, and that the father shouldn't out him, were both upheld by the Court of Appeal. The father was still not able to control himself and not give media evidence about his alleged parent rights, which exposed this child's name to people who are not going to be friendly to him. And the father is facing contempt charges. So I think that problem of how the court is enforcing access to itself in a way that is safe for trans people is a problem that we still haven't solved, because like Morgane Auger's case, the fact of going to the hearing is damaging for trans people because there was protesters and people are misgendered in the course of the hearing and dead named, and both Whatcott and his counsel referred to Morgane with the wrong pronouns and the wrong names, to the point that the tribunal had to order him to stop, and that if he couldn't do that, he could just refer to her as Ms. Auger, and he couldn't do that. He also wore quite an offensive t-shirt that I'm going to show you a picture of in a minute. And I think that in addition to the problem of how appropriate is it to ask the state to protect us from itself, it's also how to avoid the inherent and now amplified danger of pressing for rights when the process of pressing for rights through these courts and tribunals can be its own set of not just human rights violations, but other kinds of discriminatory and hurtful action, like outing and doxing. This is Jessica Yaniv. The site for this is BCHRT 222. Number 2, I think I put the year in there behind this picture of my face. Yes, 2019. I've asked, this is Jessica. She, according to the tribunal, manufactured cases against South Asian women who were providing waxing services that she found on Facebook's marketplace. And she reached out to these people with a picture and a name that were not Jessica and not looking like the picture that I just sent you, asking to be waxed, then revealing that she was a trans woman and waiting to have her appointment canceled, and then pursuing people and the tribunal. And some of these anti-trans activists represented some of the waxers for free. Yaniv herself was unrepresented. And what that counsel for the other side did, she had initially won an anonymizing order like AB had, but the tribunal found that she used that in order to use social media to further attack these women of color who were providing waxing services. She posted some incredibly racist things about these women. The tribunal also found that while most of the complained of violations would not have been accepted, the ones that would have been accepted were not going to be accepted because of the way that Jessica had behaved, and that she brought this human rights complaint for an improper purpose. I think this is I think the tribunal decided quite rightly that you can't be motivated by racism and use the tribunal to punish people. That's not its point. Its point is to remedy human rights violations, not to invite you to manufacture them and to cause them to happen in order to punish people, particularly in a racially motivated way. But the tribunal also anonymized the complainant. And what this means is that applicants to the tribunals now have this added level of scrutiny about their behavior and their online behavior, which could be put to them in the proceeding, which is why we tell our clients not to speak to the news, not to make comments, because they could be not only cross-examined on those things that they say outside of the hearing room, but they could have their anonymizing order struck and ultimately their cases dismissed based on their action. I don't think that there's a problem with what the tribunal did here. I think the decision is rightly decided in these circumstances. I think the implications for trans people's out-of-tribunal conduct, which the tribunal is giving life to, but not the same enforcement for how really anti-trans respondents behave in the tribunal. Although William Whatcott did get a gigantic, like $50,000 special damage sanction against him for misgendering Morgan, which he's judgment-proof and will never pay. But I think there's a double concern there about the conduct of complainants and the conduct of anti-trans respondents. I think that's all that I'll say about that case. It's not my favorite to talk about. It also found that there's a substantive difference between waxing a vulva and waxing a scrotum, which is not a finding that trans people need. I think what we needed was a blanket right to be able to access gender-affirming care without discrimination. But the tribunal, for a number of reasons, and you can read the decision if you're interested, made this declaration. And I think that speaks to a broader issue about how to coordinate cases for trans people and with trans complainants, particularly if they're not represented, in order to make sure that our losses don't make the world worse for the community. And I think that's what's happened with this decision. So what to watch for next? This is a dog whistle. We're looking for, I think, lots of issues that are going to have to do with the category ambiguity that we see in the administrative state. Because the state wants to know where in the binary we fall, and that we fall in a binary, and many of us don't. But the world is set up in this very binary way. And what that means is, in terms of access to services, which is pretty much anywhere that you would go in your life that's not a private club, we're going to see cases about people being allowed to go there into the facility that matches their gender. And for non-binary and gender fluid and genderqueer and gender non-conforming folks, what this means is access to spaces is even more fraught. And we can expect to see cases about this. Generally, these issues so far, in my experience with my client load, have been resolved by calling and saying, hey, can we fix this? But I foresee litigation about access to spaces, and I'm mindful of the risk that the Yaniv case presents, that there might be something special or different about our bodies that bar us from these spaces. But as we remember from the Sheridan dance club issue and the taxi company, we do have a right to use facilities that match our genders. So to say that again, trans people and non-binary folks and the whole queer alphabet in terms of gender identity have the automatic right immediately, without authorization, without legal changes, without a doctor or lawyer saying so, have an immediate right to be accommodated in terms of gendered facilities. You can use the gendered spaces that conform with your gender identity. And if there's only binary spaces and you don't identify in a binary, you get to pick. And you can pick differently day to day or minute to minute. Yay! I think ultimately this decision, this is an image of some water fountains, and one of them says colored and the other says white. This is not a question about facilities. It's not a question of water. It's a question of hate and exclusion. And I'd like us to be clear about that when people argue that somehow trans people are dangerous, particularly to women, because we're not looking to hassle anybody. We just want a drink of water or to use the toilet. Here's a tweet I sent on the day of that photograph that I showed you from the lawn of the legislature about why I was late for the photo, and some of you were there. And it's because I had to run to Starbucks so that I could pee before I showed up for the picture. And it was annoying for me on the day, but the more I think about it, I remember I used to work in that building, and I used the women's bathroom because there was only a women's bathroom. I'm way less comfortable now using gendered spaces now than I was when I worked there. And how could I possibly work or hold office in the Legislative Assembly or the Parliament of Canada without having a place to pee? So I think that's a huge problem, and we see it in post-secondary education, facilities being dealt with well because there are folks who need to access these spaces. But in some of the higher levels of power in the world, there hasn't been that thought yet. Similarly, in big law firms and many corporate environments, when it just hasn't occurred to people that trans folks could be there. And it's a physical exclusion that keeps trans people farther from justice than we might otherwise be. So when people say, well, yeah, we just need to get some trans people into office, that'll fix it. We just need to get some trans people in the boardroom. That's not necessarily going to fix it if they have to miss the beginning of every meeting because they're going to Starbucks. There's a question about toilet signs, and I'm going to skirt that by saying I think the signage on the door should describe the facilities available inside and not express expectations about the bodies of the people who might use them. If there's a change table, and there should be a change table and period products in every bathroom everywhere in the whole world, that should say so on the door. If there's a urinal, it should say so. If there's a shower, it should say so. If there's a sink and a toilet, it should say so. And there should also be a low sink so somebody can wheel up to use it, and a slanted mirror so people seated can see themselves. Yeah, and there is no good reason why every toilet drawer in the whole wide world can't just say toilet on it with a pictogram of a toilet, even if it's multi-stall. The Transgender Law Center has this fantastic activist handbook called Peeing in Peace, which is a downloadable free PDF about liberating your school or workplace from the binary. And they did a study about safety, and they found that all gender multi-stall spaces are actually the safest. And I will tell you a story that always makes me a little misty-eyed about how I took my nibblings, who are the children of my siblings, to the pool here in Vancouver. We chose this pool because I wouldn't have to go into one of the rooms with the superhero with the cape or the superhero with just the tights. I wouldn't have to make a declaration, and I could stay with these kids who I was in charge of for the day. So this pool has a universal change room. There's these little cabins and closing doors and room to put your stuff in many lockers. That part is so busy. And as we were all changing, me and these two kids that I could keep an eye on because I didn't have to push them into a room with strangers, there was this tiny Japanese couple who had come to the pool. They were frail elderly, and they were helping each other get into their swimsuits. And if they could not have stayed together, they wouldn't have been able to come to the pool and do all the social stuff and the rec and the goodness of being able to exercise without each other being able to stay together because they were each other's caregivers. So I think that's it's a good argument for why all gender multi-stall is better. It's not necessary. It's not a trans question. It's a question about being able to stay with your different identitied caregiver, to be able to stay with kids, for groups of people to be able to stay together and keep up our conversation as we all, go to pee at the show without having to break up into groups where we may be vulnerable. Because if you wanted to attack a woman now, you would find her in the women's room where we keep the women. And that safety issue goes away when there's more eyes. It doesn't get worse because we're together. It gets better. And just like the toilet at your house, it's all gender and there's no problem. That's my toilet soapbox. Okay. I want to see this kind of thing stop happening. I'll skip this slide. I think we can expect some cases about trans folks having their healthcare ignored during the overdose epidemic, because this is a true thing. I think we will see a rise of sex worker justice cases when people are struggling to get the same occupational health and safety protections that other workers are getting. I see a rise in prisoner justice coming forward. There are some folks in British Columbia and across Canada who are housed in the wrong jail. I think we should close the jails and release everyone. I don't think caging people is helpful at all, but caging people in circumstances that exposes them to very foreseeable assault and sex assault on the daily is really a form of torture. I think we'll see similar issues for migrants who are able to move here. Here are two women who were killed in ICE custody, but the same issues are happening in Canadian holding. I think we'll see some wrongful death cases. The issue both with drug users and with missing and murdered Indigenous women and with trans people is that we're not the white quarterback who can be able to sue for wrongful death with a big family with lots of money behind us. I think some more stable and affluent or at least assisted trans people will be able to argue for wrongful death when they're killed. Thank you, Erin. Here are two Black women who were killed by police. I think we'll see charges in civil court, not necessarily criminal court, arising. We'll have access to justice cases which are ongoing. Just going to show this image and not talk about it. I think we'll have some concerns that the waitlist for gender affirming care in the world, but also specifically in British Columbia, are life-threatening. And I just, have a moment to remember people who were on the wait list and are not with us anymore. I'm a white privileged lawyer and I waited 12 years to have my chest reconstructed. And we'll also see some changes in administrative processes. I'm very proud to announce that I assisted a youth client to be able to change their name. The BC Vital Statistics Agency was arguing that in order to apply for a name change, you needed a parent with custody. And this person is on a continuing care order with the ministry. And the ministry doesn't count as a parent. which meant he wouldn't be able to change his name until he became an adult. So we changed that, and now there's a process. There's no case, there's no press release. Now you need an affidavit from the social worker, which is an extra step, but at least there's a process, and none of that was done with any hearings. It was done by calling the government and negotiating with them. I know that I'm short on time, but I think I'll leave us here at this problem with hate speech, that the criminal sanction doesn't protect us. I'm going to show some pictures of some anti-trans folks. I will tell you when it's done if you want to look away. Here's a poster expressing support of a loud transphobic children's author, and an image of a preacher who was saying anti-trans things in Vancouver recently. Here's some white activists and the president of the country beneath us, who are overtly anti-trans, but also folks who are arguing and making arguments from biology, very much like the way they're discussed in OJ, in the name of protecting women understood in an essentialized way. And I think that kind of comment, which is currently being protected by bogus free speech arguments, is something that's going to change. We're going to find ways to fix that. I think also there'll be some civil damages for doxing people and for outing people. We'll come up with better ways of dealing with online harassment and online hate speech. And any trans feminine person or any person of color or any woman in politics who has any kind of public facing role will know that you get these disgusting comments constantly. We'll find a way to fix that. Doxing is when you reveal some of the personal identity of a trans person so that they can be more easily harassed. So publishing my my name and address, for example, so people could come and bug me at home to punish me for having been in the spotlight. I think we'll find a way to deal with violence through the justice system. Here's a picture of Bill Whatcott wearing an anti-trans statement and a picture of Morgane Auger in the tribunal hearing room. And the tribunal made him take it off when he gave his testimony, but he wore it every other single day. And misgendered her and denamed her through the process, which has made many of my trans clients not want to press litigation. I think we'll see Indigenous justice. I think it is, here's our friend, the coronavirus, and I think trans people and BIMPOC folks and poor people are experiencing COVID-19 in a more dangerous and fatal way. I think that is going to have an impact in law. And I'll leave you with the question, I think, of how trans people are going to press their rights when everything is closed and there's no legal aid. And the people who are really doing this work in a systematic way across the country are doing it off the corner of their desks like I am, and there's no funding for that. There's a question about what kind of Indigenous justice. I think the fact that there are 5,000 missing and murdered Indigenous women in this country, at least, and many of them are trans women, is something that the law should take account of. And being able to hold the police and the state to account for not having dealt with that is something that could be pursued through the court. And I see that I'm at my time, so thank you so much for your attention.
We're going to have to wrap it up. We're just about out of time. I want to invite our viewers, people who are not yet on our mailing list, to join up. Here's some contact information for you. There's emails that we send out with a newsletter periodically. We promise we will not swamp you with communication. It's not every day by any means. It's not even usually every week. We've got social media, as you can see up on the screen. We have Facebook, we have Twitter, we have Instagram. We have a lot of YouTube videos, and this presentation will be up on our YouTube channel in about 1 week. So tell your friends if they weren't able to come, or if you'd like to review this and take some careful notes on some of what you saw, that will be available. Again, many thanks to Adrienne and many thanks to the team who helped make this happen. Our UVic support team, Ian, Michael Radmacher, who is the admin assistant, who is amazing, Jay Watts, and again, thank you to Adrienne and thank you to all of you for attending.